Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. The Supreme Court in United States versus Rahimi issued an opinion that I think kind of upset many of the people who are big Second Amendment advocates. It didn't upset me, and the reason it didn't upset me is that I understand the dynamic that's going on here and why it was necessary to decide the case this way. And I actually think that in some respects it's a good decision. I think in other respects it's a less than honest decision, but it's a decision and it was for a specific reason. And let's get to that right now. Domestic violence is a problem in this country. It's traditionally thought of as a male to female problem, meaning that men tend to commit a lot of domestic violence and women tend to suffer from it. It's not always true. There are people who are abused by their female spouse, and it doesn't matter what the sex of the person doing the abusing is. It matters that there's violence, and that's never a good thing. And it's especially a bad thing when you're talking about somebody who is an intimate partner. That is something that drives both the national discussion about domestic violence as well as the national discussion about firearms ownership and possession. And there is some evidence to suggest that depriving people of firearms when people are at an exceptionally emotional time in their lives, like divorce, isn't such a bad thing. Yes, it's a deprivation of a constitutional right. However, when you have done as Mr. Rahimi did, as we'll find out here in a minute, it makes perfect sense. And while I think the route that the court took to get there is disingenuous, and they should have simply said, this is an exception to the historical precedent, I think that nevertheless, that this was a decision they had to make. Not only to preserve the protection that is available to victims of domestic abuse, but also to protect the legitimacy of the court. And I think that's why Judge Roberts wrote this opinion. But let me set the stage. Zaki Ibrahim was subject to a protective order. Apparently, he had been found to create a threat or present a threat to the physical safety of an intimate partner. So he was hit with one of these orders of protection. And when you have one of those lodged against you and the court makes specific findings, which we'll get into in a minute, then you can no longer possess a firearm. Usually the police come to your house and they take any firearms that you have. If you don't allow them to take the firearms when they first come, they'll go back and get a search warrant and take them anyway. That's going to happen. And if you hold on to one thinking that you can beat the system somehow, that's not going to work. And I'm not really sure whether that's what Rahimi did here or not, but at any rate, he was caught with a firearm after he had one of these orders against him, and he challenged it on the basis of the Second Amendment, and especially with respect to the Bruin decision, he challenged it because he believed that he had an absolute right to have that firearm. But just as there's no absolute First Amendment rights, the thing that everybody says is that you can't scream fire in a crowded theater. The fact is, there are limits to the First Amendment. There also are limits to the Second Amendment. And as a result of that, the federal government went after him for a violation of this federal statute, and they wanted to put him in prison. He appealed. The district court, having found against him, he went to the Fifth Circuit, and the Fifth Circuit, after the Bruin decision, reversed. The government challenged that, took it all the way up to the Supreme Court, and this is the Supreme Court's decision. So this is U.S. versus Rahimi. It's 22-9-15. It was argued on November 7th of last year. It was decided on the 21st. He was indicted under 18 U.S.C. Section 922G8, a federal statute that prohibits individuals subject to a domestic violence restraining order from possessing a firearm. Prosecutions can only proceed if the restraining order meets the qualifications. The order must either contain a finding that the defendant represents a credible threat to the physical safety of his intimate partner, or his partner's child, or by its terms explicitly prohibit the use, attempted use, or threatened use of physical force against those individuals. And that's what the order did here. Rahimi concedes that the order against him satisfies the statutory criteria, but he argues that on its face, Section 922G violates the Second Amendment. He says, in light of Bruin, the Fifth Circuit reversed, concluding the government had not shown that it fits within our nation's history of traditional firearm regulation. And here's what the Supreme Court, and this is written by Judge John Roberts, when an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment. Now, pay close attention here because he is saying temporarily disarmed, meaning that once that domestic violence order expires, either because somebody moves away or they suddenly get less angry at their soon-to-be former ex-spouse, whatever it is, whenever the violent protective order expires, then the debarment of him using firearms also expires at the same time. And so the court says, at the founding, the nation's firearms laws have included regulations to stop individuals who threaten physical harm to others from misusing firearms. And as applied here, Section 922G fits within that tradition. Now, I don't necessarily agree with that, but I think that that's one way to tether it. It says, the reach of the Second Amendment is not limited only to those arms that were in existence at the founding. Rather, it extends prima facie to all instruments that constitute bearable arms, even those that were not yet in existence. By the same logic, the Second Amendment permits more than just regulations identical to those existing in 1791, meaning that this regulation is now effective because things have changed, right? It's a new era, so to speak. This is the most dangerous part of the opinion in terms of the Second Amendment, because you could use that logic to justify pretty much any impingement on firearms. But he goes on, and he says, a court must ascertain whether the new law is relevantly similar to laws that our tradition is understood to permit, applying faithfully the balance struck by the founding generation to modern circumstances. Why and how the regulation burdens the right are central to the inquiry. As Bruin explained, a challenged regulation that does not precisely match its historical precursors may still be analogous enough to pass constitutional muster. Rahimi's facial challenge to 922 requires him to establish that no set of circumstances exists which the act would be valid. And because he was found to present a credible threat of physical safety to others, the government offers ample evidence that the Second Amendment permits such individuals to be disarmed. So what did they do to justify this historically? Well, they went back to the surety laws, which were a form of preventative justice. They authorized magistrates to require individuals suspected of future misbehavior to post a bond. Now, I don't believe that would be consistent with our general understanding of the law as it exists today. And so using it to, justify what's happening today is not, it's not precisely in congruence with the Bruin decision. And I think people who read the Bruin decision would understand that. And then going on, it says surety laws would be invoked to prevent all forms of violence, so there's no reason it couldn't be offered to protect spousal abuse. The going around laws, a particular subset of the ancient common law prohibition on affrays or fighting in public, provided a mechanism for punishing those who menaced others with firearms. Together, the surety and going armed laws confirm what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. But Section 922 is not identical to these founding-era regimes, but it does not need to be, according to Judge Roberts. And with that, you pretty much have the entire heart and soul of this case. They found that this guy presented a credible threat. They found that that threat was serious enough to issue a restraining order. Usually restraining orders mean that you have to keep your distance, that you have to avoid contact, that you can't harass or stalk someone. And so the idea that this gentleman has been debarred from having any contact with the person who has the restraining order, well, that pretty much establishes that there really is a credible physical threat there. Now, if you look at the makeup of the court, there are 4 women and 5 men. And those 4 women on the court, I believe, had a pretty strong role in shaping this opinion. Because I'm sure all 4 of them have at one time or another come across a crazy person who, in some way threatened them or threatened a loved one, threatened a daughter, threatened a niece, a nephew, somebody like that. Somebody who has done something to come to the attention of the law that they would not want to have access or ready access to a firearm. That's important. I think this is one of those opinions where all 4 of the ladies on the court were, in agreement that this was a proper exercise of discretion. And as a result, they found that if you present a credible threat of physical safety, they can take away your guns. But Judge Roberts did say that it was temporary. Now, a lot of times that can be altered if if you're found to be, a mental case, if you are, not right in the head and you're running around threatening people, that prohibition against owning arms is going to go away, because once you are found by a competent court or a court of competent jurisdiction that you are, not right in the head, so to speak, then you're not going to be able to buy a firearm. Your name's going to go into a database and you're not going to be able to get access to it. So all of these things work together to prevent a certain kind of violence. And that violence is the violence that occurs when somebody gets mad at an intimate partner. And women can get mad at their husbands or their boyfriends just as easily as the other way around. But the bottom line is, whenever somebody has one of these orders taken out against them, well, they're going to be stripped of the right to own firearms, or possess firearms. I'm sorry, not own, possess. That's really important because, in my opinion, one of the things the court isn't considering here is that sometimes people who really are evil will get a protection order against a woman, claiming that they've threatened violence solely for the purpose of disarming them so that they can go and, beat up on them. And that isn't right either. That is something that's going to have to be addressed, I think, probably in future cases. But the bottom line is, the main overarching reason why this result reached the result it is, 2 of them. 1, the ladies on the court, I think, were very much in favor of this rule. And 2, there's been a lot of political pressure on the court. There's been a lot of media attention to domestic violence. And I think all of those things are taken together, have created a situation where the court felt that it had to uphold this particular statute. Does that mean it's going to uphold other parts of 922G? Maybe, maybe not. We'll just have to wait and see. That's what I have for you today. If you have any questions about this, please feel free to drop them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. If you have the opportunity today, do a kindness for somebody, and then come on back here tomorrow, join me at the beach, and we'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.